Good evening. My name is Stephen Taylor, and I'm an attorney for the defendants in this case, the Crane Tragors. In their statement of the case, the plaintiffs have claimed that a contract for sale formed because there was an agreement between the two parties and that the conduct of the two parties supported the existence of such an agreement. We, the defendants in this case, contend the exact opposite, that the actions of the Crane Tragors show that they intentionally and specifically did not mean to enter a contract for sale, and that their conduct supported such a position. Now, Section 2204 of the UCC says that the conduct of parties may be sufficient for the recognition of a contract. At the August 20th meeting, when the Vernons and the Crane Tragors met to discuss the sale of Riot Foods, Gene Vernon suggested that the parties sign a contract for sale to signify the transfer of the business. However, on this August 20th date, my clients, the defendants, the Crane Tragors, were still unsure about entering the food service industry. Understandably so. They wanted to take some time before making such a serious business decision. However, the Vernons did make them aware that there were other interested parties in purchasing Riot Foods. So my clients stated that they would not sign a contract for sale because they were not prepared to do so yet at this point. However, because they understood there was interest from other parties in the business, they offered $15,000 for the right to consider the purchase of the business through the summer. Now, my client's conduct shows that they acted intentionally to not enter a contract for sale. Um, they, Once they took over the business, the Crane Tragors did not expand the business. They didn't change anything from the way the Vernons had run it. The Vernons had scheduled 8 events that summer, 2 of which Gene Vernon worked with the Crane Tragors for, and the other 6 he didn't work at, but they continued to work. They did not schedule more events. They didn't change anything. They didn't rebrand the company. And they didn't do anything besides operate the way that the Vernons had operated previously. The agreement between the two parties indicated that my clients would be able to have full use of the facilities and that their expenses, in addition to the $15,000 they were paid in order to secure their right to consider the purchase, they also had to pay for any inventory used over the summer. And because they were the ones doing all of the work, it was also the agreement that the Crane Tragors would get to keep the income. Uh, Further illustrating this, the Vernons never transferred the title to my clients, the alleged purchasers, and the entire time, everything remained in the Vernons' name. Once the summer ended, the season ended for the food service truck, the Crane Tragors returned possession of the vehicle to the Vernons, and they opted not to use the option which they had secured for $15,000. So, in summation, it is my client's position that they did not enter a contract for sale with the Vernons because there was no agreement for a sale. At the August 20th meeting, when asked by the Vernons to sign papers, my clients refused to do so because they weren't prepared to enter a contract for sale. They did not want to, and they made that clear at the August 20th meeting. And furthermore, the plaintiffs state that there was an understanding of the sales agreement pending the bank loan, and there was clearly not an agreement on that matter because it's my client's contention and understanding of the matter that they were merely paying $15,000 for a right to consider purchasing the business through the summer over the interest of the supposed third parties. And as such, no contract formed because it was not the understanding of the parties. Thank you.